Okay.
We are streaming.
Commissioner Tarrant Reed, Adem and I may be switching in terms of order.
Say it again.
Adem and I may be switching in terms of order, if that's okay.
Okay.
Thank you.
Why? Because he's not here yet.
He is here. I'm not sure what's going on with his microphone. Adem, if you can hear us, if you can contribute
Yes,
to this.
yes, I
Cool.
can hear you. I'm here.
All right, thanks, Adem.
All right.
Okay, are we going to be able to see them?
Yeah, whoever is doing like active presentations or anything, we'll put up.
Okay. So, Adem, you're supposed to be first.
Yes, but we are going to switch, swap it around.
Okay, so
India will go
that's-
ahead of me.
Okay, so India, you're going to go first. Is that what I heard?
Yes, ma'am.
Thank you. I'm sorry.
No problem. Thank you.
Good afternoon, everyone.
Good afternoon, Commissioner Daniel Favors.
Oh, good afternoon, Commissioner Daniel Favors.
Good
Happy
afternoon,
Friday.
Commissioner Favors.
It was nice seeing you the other day.
It was indeed. That was pleasant. I'm glad the college was able to celebrate Caribbean Heritage Month with the governor, and to see you there was an added bonus.
The college is quite beautiful.
I agree.
Is Commissioner Hoag's here present?
Not yet.
Okay. Let me see where he is. Stewart. Who's that? Well, tell them to come in. Hi, Lisa.
How are you? I'm good. Good. Nice to see you. How's everything? Good. I was like in ratty jeans and t-shirt and it's like, let's go.
You could have done that.
My mother would have haunted me from her grave. How are you doing?
Out of an abundance of caution, may I suggest that we have that microphone muted, please?
How you doing, Commissioner Linda Tarrant Reed?
Commissioner Jenkins has arrived.
Okay, so
Commissioner who?
Jenkins,
Oh.
Dr.
Yes.
Jenkins. Okay.
Understood. How would you like me to assist you with Commissioner Jenkins?
That's that AI technology. You better be
Oh
careful.
my goodness. You know how I feel about that.
Oh yeah, yeah.
It's
get it.
problematic.
I get it. So we are live.
Are we live?
Is that correct, Jim? We are live, and so as soon
We're live.
as Dr. Jenkins could get in place, we will start.
Folks are filing in, Commissioner Hogue. As is Commissioner Jenkins.
Start with council.
Oh, I'm sorry.
Hello,
That is
council. How you doing?
That
I
is
see you
not
doing.
Commissioner
I see you double tap. Go ahead, finish doing what you're doing.
Oh.
I see you
Oh,
checking some stuff.
just a little bit. Yes, yes.
All right.
Good to see you
It's great to see
virtually,
you as well.
obviously.
Yes.
Okay, I'd like to call this meeting to order. We're
It's
about 10
3:12.
minutes.
It's
We're about
3:12 p.m.
Commissioner Hogue,
Yes.
I'm going to call the meeting to order.
Okay, it's 3:12 p.m. and we can start.
Thank you. Good afternoon, everyone. Welcome to the New York State Community Commission on Reparations Remedies. This is our business meeting. Several of our commissioners are arriving. They'll be arriving late, but in the meantime, we're welcoming you. We're required to have the public attend, but because it is a business meeting in which the commissioners conduct our business, and as you guys know, our business right now is focused on the final report. In the meantime, we will have presentations by two of our staff members. Our first presentation will be by our general counsel, India Sneed Williams. India, are you ready?
Thank you so much, Commissioner.
It is a PowerPoint.
Yes.
Could you can you introduce your presentation so people will have some kind of context?
Of course. Before I do that, I just want to make sure you all are seeing the appropriate screen. It should just be the screen, the slide, and not my notes.
Yeah, we see everything.
Everything. Okie dokes. All right, give me one moment, please.
And while we are at it,
How about now?
that's perfect. Commissioner Tarrant Reed, you want to introduce yourself and tell them where you are?
My name is Commissioner Linda Tarrant Reed. I am a historian and author. And today we're having the meeting at the Lincoln Park Conservancy's History and Culture Center here in downtown New Rochelle. I am the executive director of this nonprofit, and I am excited and pleased to be hosting the commission. I am working with several of our vendors on the final report. I am working with the research historian. Also, I liaise with the communications vendor. So there's a lot of work that all of us are doing, and that's just part of it. Commissioner
Thank you.
Hogue.
Hi, my name is Commissioner Tim Hogues, and I am in Rochester, New York, at the Memorial Art Gallery located at 500 University Avenue in Rochester, New York. My daytime job is to be Commissioner and President of New York State Civil Service, and we are excited to be able to serve. And so we look forward to the information that we're going to get and the updates that we're going to get during this presentation. As Commissioner Janet Reed mentioned, this is a business meeting, and so there's not the opportunity for online or in-person questions from the audience. And so with that said, I don't believe we have any old business. I don't believe we have any old business. And I believe we have another commissioner that is joining us remotely.
Yes.
If you are available to say hello.
That would be Commissioner Lurie Daniels Favor.
I don't
Do
know
we
if we
have
have.
her?
If we don't, we can patch her in a little bit later to say hello. Council?
Okay,
All right.
let's move on.
Sure.
Introducing again the General Counsel, India Sneed Williams, and her presentation. India.
Thank you so much, Commissioner. By way of introduction, my name is India Sneed Williams, and I'm General Counsel to the New York State Community Commission on Reparations Remedies. I am licensed in New York, DC, the Southern District of New York, Eastern District of New York, and as of the latest, the Supreme Court of the United States. Today, I'm presenting legal frameworks that have been utilized in the creation of reparation programs throughout the country. Please note that while this is a distilled recitation of the information in case law, that the issues and items are very nuanced. The purpose of the presentation is to help ground the Commission's work by understanding what's already been done in other jurisdictions throughout the country. What we'll cover today is the New York State authorizing legislation, again, just to set the frame and context of our work. We will then go into legal frameworks and reparations definitions used in other jurisdictions, eligibility frameworks, harm definitions by area, as well as some of the current litigation that is ongoing. So the New York State Community Commission on Reparations Remedies is charged with examining the full history of slavery and government-sanctioned discrimination in New York, from the institution of slavery itself through present-day racial inequities affecting people of African descent, and recommending appropriate remedies, including potential compensation, eligibility criteria, and the administrative infrastructure needed to deliver on reparations. This slideshow is public, so if you all want to review it afterwards, that is something that you can take advantage of. For time purposes, I will not go through all 8 of the specific mandates, but as you read it on your own, please keep in mind that the language is extremely important because it sets the framework, the limitations upon which the commission can do its work. All right, so first we'll jump into the legal frameworks that exist for reparations. The first is tort. It's a legal term, and a tort is a wrong that has caused harm to someone. I'm sorry, a tort is a civil wrong that causes harm or loss to someone, leading to legal liability for that person or entity who caused it. Tort law focuses on making the injured victim whole again through financial compensation. It's a form of litigation. So if you're injured in a car accident and you sue the person who was involved in the car crash, you are engaging in tort law in many cases. Required elements of a tort are duty. You must show that an individual or entity owed a legal duty to the harmed party. Second is breach. You must demonstrate that the actor violated the duty. It must be causation. You must establish a direct line between the act and the harm. And finally, is damages, which is quantification of the harm. I also should have mentioned that a lot of legal jargon is going to be used. I will try my best to either explain the terms, but quite frankly, if we're having a legal conversation about reparations, it's best that we use legal terminology at the onset and we just become very familiar with it. Okay, some areas for tort application and reparations include eminent domain and property takings, targeted racial massacres, as well as redlining. The pros of a tort and engaging in tort law for reparations is that economists can calculate precise dollar figures. Targets targeted entities and actively instituted, that actively instituted and profited from harm can be targeted. And then there's publicly made documentation of the harm that was caused. The cons include limitations and liability based on statute of limitations, which means a defined time period in which you can bring a case. Secondly is a term called attenuation, which basically means that there has to be some correlation between the party that is bringing the suit and the party that actually experienced the harm themselves. Third is that courts have routinely dismissed reparations programs that have been brought under tort, primarily because the plaintiffs do not have the ability to prove concrete personal injury. Basically going back to that attenuation phrase we just went over. The second one is human rights violations. Under human rights violations is where we find our United Nations basic principles and guidelines. This approach shifts reparations from a domestic petition to an international law. The best example, as I mentioned, is the United Nations. And under that framework, there are 5 pillars under which reparations should be made. One is restitution. Second is compensation. Third is rehabilitation. Fourth is satisfaction, and then guarantees of non-repetition. In one of the later slides, we go into a little bit more detail about that. Pros with going with the human rights violation is that there's global precedent. It's an elevated moral weight by reframing a domestic debate into a universal human rights issue. And then there's generational scope. So it naturally accommodates the multi-generational harm that is experienced by parties. Cons, lack of direct enforcement. The UN, surprisingly, has no jurisdiction over the United States and can't force the United States to actually do anything. So if we were to take a matter to court, we can tell the court about the UN's definitions on things and their requirements and certain other aspects, but we cannot expect the court to actually follow the UN framework. Again, it's just not a precedent. There's no binding by the UN on United States courts. It's merely persuasive. Best use, still, in chattel slavery and arguments on reparations about that. Systemic apartheid and segregation, as well as cultural genocides. Third is criminal law. This is actually a pretty obscure way of bringing about reparations, but in standard criminal law, the state prosecutes a wrongdoer for violating public laws, such as enslavement, murder, rape, kidnapping, and it requires that the wrongdoer be prosecuted. And the pro of it is that it provides accountability. It pierces state shields, which overrides certain civil immunities. And the cons is that it's an extremely high burden of proof. You have to prove beyond a reasonable doubt. And then there's the ex post facto prohibition, basically meaning that you cannot bring a claim under criminal law for something that was not illegal at the time that the crime took place. Okay. The next one is crimes against humanity, murder, extermination, enslavement. Excuse me. Sorry, I lost my screen, folks. Sorry. Give me one moment. I am managing my screen over here. Apologies for that. Annoying. Continue to share. Okay, cool. Back in business. All right. Here we go. So crimes against humanity, murder, extermination, enslavement, deportation. Then we get to, oh my God, I did it again. Then finally, we get the legislative and policy frameworks. A portion of the work that the commission is mandated to do is engaged in an exploration of possible legislative and policy frameworks. All right, so this next slide is basically taking us through various jurisdictions to get a better understanding of which frameworks they actually utilize. The first one is the city of Evanston. Currently, they have a reparations program that is tiered and programmed to give people who are eligible a certain sum of money to do a certain thing. We'll go into the details of that further down the line. But they have brought their reparations framework under a human rights violation. And that complements the National African American Reparations Commission, and it also has portions of it that are modeled after the UN framework principles. The next is California, which has been a very popular program in terms of really being one of the first in the United States to actually prepare a program and present it to the public and actually see to it that the recommendations within it are executed upon. They used a hybrid framework that focuses on human rights violations as well as tort-style economic calculations. With that, they basically surmised that X amount of people were harmed. They described the people in their eligibility, and they said that based on certain occurrences and harms that those people experienced, they were eligible for X amount of money. Like I just kind of walked you through, the tort-like calculations determine monetary damages specific to categories of harm, which are embedded in the human rights framework. Then we have San Francisco, which is a place within California, a municipality within California. They also took the approach of the human rights violation framework, using the UN definition of reparations as its founding operational mandate, and use events-based harm. And they premised their UN portion of the pillars on compensation and satisfaction. Also, another reparations program that took place in the United States was the Japanese American Redress Movement shortly after World War II. Their position was also hybrid, where it was legislative and constitutional harms of human rights violations. So what a lot of people don't know about Japanese reparations is that it actually started as a court case where a population said that the United States, harmed them, and therefore they were entitled to a sum of money. That court case failed, and it was struck out. And instead of going the route of court, they applied so much pressure to Congress that they were actually able to get their reparations legislatively. So what that tells us in some cases, or at least historically, some parties have failed, and from that failing have developed new strategies in which we are able to take advantage of as the state of New York. Finally is Asheville, North Carolina, which also used a human rights violation framework, again, modeled after the UN's framework as well as the National African American Reparations Commission. And the pillars upon which they have modeled their reparations program is through satisfaction and rehabilitation. Okay. So next section is the eligibility frameworks. We know from our own personal experience that this is a very divisive topic, and it's really important to understand not just the framework and its definition and the population that it may represent, but also the pros and cons in terms of how it will be litigated. It's not if, it is when it is litigated, how the opposition or opposing parties are going to try and break through the program that we create. So the first is lineage-based. So lineage-based, as it says, it's a policy framework that restricts eligibility for direct descendants, right? It's compensation that is strictly to individuals who can prove their biological descendants, or a relationship to a person that was formerly enslaved in chattel enslavement, right? A pro is that it survives constitutional challenges. That is the blanket approach, right? Or blanket understanding of its survival of constitutional challenges. A caveat to that is that more recently in certain court cases, namely Cayetto, is that lineage can be deemed a proxy for race. Once we talk about race in a couple of minutes, we'll see why that is really important to keep in our back pockets and understand. Another pro of lineage is that it targets the specific unjust enrichment and the compensation related to the stolen labor of chattel slavery, which is owed to descendants. The con is that, or a few cons, are that it ignores modern systemic harm, and thus a forward-looking of the UN framework, a forward-looking aspect of the UN framework is completely ignored. And that is promises not to engage in the same behavior down the line. A second con is the proof barrier. As we know, our people were not documented for. Our birth certificates, death certificates, marriage certificates were never even contemplated for because we were solely deemed as property. So DNA is probably one of the ways in which one would become eligible. Genealogical resources would probably be very necessary, as well as the documents. However limited they are, some people definitely do have documentation of their history, which would help them become eligible under a lineage-based eligibility framework. And as I already mentioned, it's arguably used as a proxy for race. The notion being that enslaved persons were Black. We know our history says that they were Black, indigenous people in some cases and others, but the majority of enslaved persons were Black people. So with that understanding, and the argument is made that lineage is being used as a smokescreen. Okay. So second one is race, right? So anyone who currently checks the box as Black and lives in a jurisdiction, did it again, so sorry. Continue to share. Yeah, so anyone who currently checks the box as Black and lives in a jurisdiction would qualify for reparations. This also includes immigrants, recent Black immigrants from Caribbean and Africa. Location and based eligibility criteria. So this offers a benefit to an entire demographic, which in some people's minds would offer a non-benefit to the population that we're actually trying to get to and repair the harm that has been caused. But it basically models itself off of location. Where do you reside, right? So we are the New York State Commission for Reparations. So New York State residents would be the ones that qualify. This can be even more targeted to zip code, district, name of an area that we know was redlined historically. So this can be a very useful tool. Time and duration based. This basically adds a time frame caption to the periods in which the court or the legislator or whoever it is that is actually implementing the program would look to make sure that the harm that is ascribed to a person took place within a certain time frame. And then finally, and more recently, there's been application of tiered and hybrid approaches, which uses a combination of all of these in some cases to create eligibility frameworks. So we kind of just went over some of the definitions. It was helpful for me to see this type of presentation in that at the very top, we have lineage, and we said that that is creating a more narrowly tailored approach to reparations being disseminated. Next, you have hybrid, which allows for some creativity. It's crafty in the sense that you're still narrow, but moderately narrow. Time frame, as we mentioned, it broadens the eligibility, and then geographical location can do the same. And then race in some ways is the broadest way to approach the eligibility requirement. So lineage, like we said, it's individual bloodlines. It's the most restrictive tier. It filters out the vast majority of the population, requiring strict genealogical proof of direct descendant from a specific historical harm. The hybrid model, it's narrowish intermediate. Its use of overlapping qualifiers is what makes it very useful. Why it's here is that it's used in the California task force. Even though they use the word lineage, it is actually a hybrid model, and we'll get to that. It significantly narrows the pool by forcing an applicant to meet multiple distinctive criteria simultaneously, such as proving Black ancestry and living in California during a specific period of time, and experiencing a specific harm. Time frame based is also intermediate, but like we said, it's a little bit more global in that it ascribes a generational cohort or specific historical era. Historical eras such as the Jim Crow era. These would be, I'm sorry, Jim Crow era, the Rockefeller drug law era, era of time where it was illegal to engage in stop and frisk in certain jurisdictions. That's more so what they're talking about in terms of time frame based. So it's applied to a specific duration of time that a harm occurred. Then with the geographical location, it's place-bound populations, neighborhoods, cities, and states. And why it's here is because it casts a wider net by including anyone who holds residency, property, deeds, or school records within a specific municipal border or red line district, regardless of their family history or ancestry. And we discussed why that is somewhat problematic in terms of targeting the folks that we are trying to target. Finally, the race-based, broad demographic populations. This forms the widest base of the pyramid, and it blankets entire racial or ethnic groups across the country. So whether you have enslaved ancestry, whether you are newly immigrated from another country in the Caribbean or from Africa, it's a wider pool. Now we'll go through the jurisdictions and how they made their or crafted their eligibility frameworks. So Evanston, Illinois, hybrid. They focused on race, geographical location, and time frame. I mentioned earlier that it was tiered. So to qualify for this restorative program, the applicant had to be Black and have lived within the city of Evanston as an adult during a strict time period. I think it's 1919. I can't see the second number. It might have been like 1968. Second is California, which says lineage based in their definition, but as you actually go through the recommendations, you see that lineage is not a qualifying factor and that the recommendations are a little bit more global in terms of who they're targeting. So I think California is very smart in how they framed their eligibility, but as you actually get through the thing, it's much more comprehensive than just lineage based. San Francisco is also hybrid, race, geographical location, time frame. And it requires applicants to identify as Black or African American for at least the past 10 years and meet 2 secondary criteria from a menu of options. Some of them included having been someone who was incarcerated during a certain period of time or their direct ancestor, or having been educated in a San Francisco school during a certain period of time, or in a redlined area. So they created a complex matrix, so to say, of eligibility criteria. Here we talk about Asheville, North Carolina as well. They have used a hybrid framework for their reparations programs. So rather than tracing the individual bloodline, they target its municipal investments directly towards residents harmed by historical urban renewal zones. The thought behind this approach is that if the urban renewal zone was created with the intention of harming Black communities at that time, naturally it would flow that Black people who are harmed are the ones that are eligible. With this approach, yes, there are maybe a handful of non-Black people who may have still been affected at that time, but in comparison to the amount of people that it actually is able to assist or benefit, it's to be argued whether it's worth the cost. Then finally, there's Japanese, which I said earlier, offered a hybrid framework in that it was time frame and lineage variant, had to be living survivors only. Eligibility was strictly limited to individuals of Japanese descent who were forcibly relocated between December 7, 1941 and June 30 of 1946. Okay, then we have the harm areas. Some of the jurisdictions that have created reparations programs chose to focus on solely one area of harm. Some chose to focus on a multitude. The most comprehensive is California and San Francisco, in that they are working on education, criminal law, environmental justice, the wealth gap, housing, and employment. So I apologize for how dense this is, but basically from top to bottom is the jurisdiction, then from left to right, it just discusses the different forms of harm that were targeted in their reparations programs and how they tried to basically attend to it. So California, for their housing discrimination and property takings, here you'll see formally identified housing segregation and redlining between 1933-2020 as a primary harm. So we have to go back a couple slides to think about eligibility, right? So we have a time frame here, and we have a specific harm area. So if you were to create a California matrix, you would have to match up with their eligibility and pursuant to time and the specific harm to be eligible for this housing-based redress. When they tried to target the criminal legal system and mass incarceration, decades spent enduring over-policed and mass incarceration during the National War on Drugs. So that's a specific time period that they have identified. With regard to health and medical, they identified generational neglect and environmental harm. For Evanston, their exclusive focus was on housing. That was it. Housing, not jobs, not job creation, not health and wellness, nothing else. They solely focused on making sure that the people who were harmed during a specific period of housing discrimination were the ones who benefited from their program. San Francisco, they opened it up to people who were harmed during periods of urban renewal, which was a specific time frame. With regard to criminal legal system, it was localized harm of disproportionate Black arrest rates. Health and medical, they identified disproportionate mortality rates throughout the system and environmental hazards in neighborhoods. Asheville, they focused on urban renewal and city zoning. If we go all the way to the right under health and medical were, I guess, tertiary targets that were related to housing discrimination. And so they were indirectly managed through housing and discrimination. Japanese redress, that was indirectly addressed through payout for partial compensation of severe economic property loss. So basically each eligible applicant for reparations under this Japanese program was entitled to a lump sum of money. And through that lump sum of money, it was assumed that housing, criminal, health, etc., would be taken care of. So this is just more of the harm areas and how these particular jurisdictions addressed each harm area. So an apology. California got an education. California got a formal apology and monetary support for public education and memory initiatives through through statues and arts activations. Then for the stolen labor, they have you had to have documented that the stolen labor hindered opportunity of chattel slavery alongside ongoing suppression of Black business owners. So in this one, they're addressing economic development, labor to a certain extent, as well as the stolen labor. Voting rights is not addressed in any of the reparations programs. So that would be something to explore here in New York State. If you go down to Evanston, you'll see that they also passed a formal apology resolution as part of their program, and included public education. Evanston, again, only focused on housing, so the other two categories are not addressed. San Francisco, as well as Asheville, also passed formal resolutions for apologies and public education or memory initiatives. San Francisco outlined historical economic exclusion, whereas Asheville adopted the urban renewal, which destroyed Black business. So they adopted that model. And then, as mentioned in the previous slide, lump sum of money was given to Japanese recipients of the program, which assumed that it addressed all these other harm areas.
General Counsel, it looks like in that fourth column that environmental justice is in that bucket as well. So it doesn't appear that any of them chose to look at environmental justice.
No, thank you for calling that out. On my screen, my head is blocking that section of the. So I really appreciate your participation here. It's very helpful. Thank you. So just for the record, so it's very clear, in terms of this fourth column, it reads voting rights, environmental justice, employment, and pupil education. None of these jurisdictions addressed that as a harm area or addressed those as harm areas, which again would be something for New York to potentially explore. All right, I promised you that we would discuss current litigation. So currently, the most prominent jurisdiction being sued is the city of Evanston. So it's Flynn et al. V. the city of Evanston. Flynn is the named defendant that is representing a class of non-Black people who are basically suing the city, saying that because of how the reparations program was designed, and just inclusive of or requiring that Black people be the recipients of the program benefits, they're saying that non-Black, well, I'm Black, non-Black residents are the ones that are not able to be afforded this benefit or not eligible to be afforded this benefit. And that's what they are suing for. Legally, if they are arguing on a violation of their equal rights their equal protection rights, that basically guarantees that no race will be denied a benefit. If we actually go back to the Reconstruction period and study the Reconstruction amendments, that's the 13th, 14th, and 15th. 13th, 14th, and 15th amendments were explicitly drafted for the benefit of Black people because it was very well understood that they were newly freed, we were newly freed, and that the benefits afforded to white people and other people were not the same that were prescribed to us. So they felt it important to actually put it into law, a benefit for Black people. So when we see these laws being used in reverse and against us, I think the court often needs a reminder of the spirit of and the letter of the law that was actually enacted. This is a discussion that is actually brought up in a couple of Supreme Court cases by judges who have actually dissented on previous matters, such as Board of Education or Plessy v. Ferguson. But more about Flynn and the city of Evanston. So in 2024, 6 non-Black descendants of Evanston residents filed a class action lawsuit that challenged the city's restorative housing program that provides a $25,000 payment. Then in March so they brought the case, the court has allowed it to progress. That brings us to March 2026, where the court denied the city's motion to dismiss. So the city attempted to get the entire case kicked off the list of cases. Unfortunately, they were unsuccessful and that case was allowed to proceed. The judge on that matter, who was actually, the judge who decided that and is the judge for the entire matter is actually a Trump-appointed judge. So in June 2026, which is this month, so last week, the Trump administration, that Department of Justice, his Department of Justice moved to intervene, which is somewhat of a rarity in these cases. But a move to intervene is simply a move to be added into the arguments and kind of become a party of the case. So this is actually pretty big. And it's actually an escalation of the matter in that the DOJ has decided to intervene and become a voice that they are lending to the Flynn side of the case. They're not supporting the city of Evanston side. They're supporting the plaintiffs who are arguing over this reparations program. And their arguments mirrored pretty much what the initial plaintiffs were saying, that this program violated both the Equal Protection Clause as well as the Freedom of Information Act. And like I said, it's an escalation by a government entity. The city of Evanston has maintained throughout that their program is lawful. And they remain confident that they will withstand the judicial scrutiny. Why this is one to watch is because we want to see how the court treats the use of Black, right? How they treat Black is something that we will have to take into consideration as a reparations program. That doesn't mean that we're stalling and waiting for a decision in Evanston. By no means. It's just one that we have to continuously watch. And as other court cases enter the scene, we also want to monitor those and watch those. Finally, just some closing words on New York State's reparation program. I look at this presentation as a part one to just lay some of the groundwork for our commissioners and more importantly, our public attendees and viewers to just understand what's already been done to kind of give us a roadmap of how we could move forward. So legal framework will ultimately be one that is the most defensible and supports the fullest extent of redress for impacted people. Eligibility is going to be informed by the authorizing legislation and our findings from research of court case precedent. And the harms will ultimately be informed by categories of harm identified by participants from our public hearings and from our research and findings. So the work has been ongoing. This is our first of hopefully a few presentations on our legal framework just to inform the public. And with that, I close. Thank you so much for your time.
Thank you.
Thank you, General Counsel.
Thank you.
Okay. Any commissioners? First of all, good afternoon. I see that we have Commissioner Larry Daniel Favors with the question. Can we unmute Commissioner Daniel Favors?
Thank you so much, Madam Chair. I hope you all can hear me okay.
You can.
General Counsel Sneed Williams, first, let me just thank you for a thorough review of the current state of affairs. I'm curious as to how you plan to keep track as to what the current administration's positioning is on these cases and how you think we can best factor that information into the deliberations that we have as a body, and then as it pertains to how we frame the report. Obviously, we will want to recognize that there is a new legal framework that we are operating under that even is more recent than is the Evanston effort and some of the other efforts that you mentioned. I'm curious as to how you think we as the commission can be best prepared to factor that information into how we frame the report. How should that knowledge guide our deliberations about what we include in the report, what we don't? I'd appreciate if you could just speak to that a bit.
Sure. So to the first part of your question, how I'm keeping track, I have legal alerts on my LexisNexis accounts that feed me information as it happens. The information being court cases and court decisions. So it is my job to stay abreast of that, read through that, understand the court's interpretation of a particular issue, and share it with the commissioners. In terms of how I would anticipate commissioners use it is, in some cases, it's going to be cautionary. In some cases, it's going to be completely prohibitive of how we move forward. But my job is to read it, interpret it, distill it, so that the commissioners can make informed decisions about risks that are associated with certain positions, as well as likelihood of success. that's my answer. I hope I answered all the questions.
Indeed, you did. As a follow-up, I would ask if you could also speak further to how our communication strategy should factor in this information. And I ask that because we want to ensure that in addition to submitting an effective report, that the community, which is going to have the job of advocating on behalf of this report and going to their elected officials and essentially becoming the lobbyists for this report, if they want to see the recommendations implemented, how should we prepare the community for what this new legal positioning means? Most of us are experiencing the world where the dismantling of the legal framework that supports integration, diversity, equity, and inclusion is being dismantled for the first time for us. And so because we know that the community engagement component is going to be important, how should our comms strategy factor in educating the community about the fact that the Department of Justice is taking an active role in opposition to these efforts, so that the community is as prepared as possible to do the work of advocating as effectively as possible, to the extent they wish to see the recommendations from the report implemented, voted into law by the legislature, and then signed by the governor?
Right. Great question. One, I want to start by just applauding the commission on being on the ground and in communities to share the information. We've had a series of public hearings that have really gotten a lot of information out. I think it'll be important as we move forward to share information just like this that I did, right? In terms of giving the community an idea of what the environment is for reparations, what it is for a lineage-based program, the pros and cons, what it is for a race-based program, pros and cons, and how that is discussed and manipulated in some cases by judges. It's going to be more important now than ever for us to be very intentional about putting the information in our people's hands. I will do a better job at that, right? And be more intentional about it and making it not just digestible, but something that is also shareable, right? So that it's not just you reading it and digesting it and still maybe a little murky on what's happening, but something that you can take off to your community. And when you go to church, you can say, hey, look what I discovered. Getting the information in people's hands is what's going to be really important. So working closer together with the communications team is something that I'm looking forward to doing.
Thank you.
Other questions? Thank you,
Can New
General.
York City hear us?
Question, I have a comment, but
I think
I'd
they
like to
can.
wait.
Go ahead.
No, I'm not waiting. No, let's have questions.
No, okay. I have a comment as well. I thank you, General Counsel, for gathering all of this information, giving us a viewpoint of what's happening throughout the nation. I think it's very valuable to our process, and I thank you for it. I want to shout out those two jurisdictions that you did say included environmental justice, San Francisco and California. If we as elders are not realizing that we have to center environmental justice in this reparative work, our young people are, and they're not really represented here. And so I think it's one of those harms that we have to elevate and amplify, most definitely, because then we won't have the young people who we say we're doing this for supporting our work. And so kudos to those jurisdictions. And we want to give a shout out to Sister in Evanston for sharing with the chair the updates so that we can be, Robin Rue Simmons, yes, so that we can be informed. And we thank you for your efforts, and we look forward to continue your continued legal framework work and sharing it with us, and how we can continue to get the word out into the community. So again, thank you.
No, thank you. And just to get to the environmental justice part, that is currently my team's focus in looking at current laws and current status of community as it relates, not just to environmental justice, but how that fed into redlining and zoning and a lot of harm that is being caused currently.
Any questions here in Rochester?
I don't know if there's more.
Well, I'd like to comment if I might. If there are no questions. Actually, a series of comments. And forgive me for being a little late. I'm just, well.
Can we
anyway.
pull your mic closer?
Oh, I'm sorry. Let me identify myself because I was late getting here. I'm Dr. Ron Daniels, and I am honored to be a part of this commission. I am also, however, the president of the Institute of the Black World 21st Century, and I'm the convener of the National African American Reparations Commission, which was referenced several times during the course of this report. We established NARC for the very purpose of being an authoritative body to address the questions that are also being illuminated. In that regard, just as an aside, I would say that on the communication strategy, it seems to me that the communication strategy, having heard the challenges and opportunities, would sort of shape that strategy. The legal counsel has done her job in terms of just laying out what the issues are, and then it seems to me the comms team should take it from there. I think it's important to. There was a comment about the Japanese reparations, because I want to, as an OG and an ancient one, sort of say a few words in that regard, because I want us to understand sort of the political context. So the Japanese first went to the courts, and the court said no. They mounted a campaign legislatively, which succeeded. It succeeded in part because if you go back to that era, whereas China today is seen as sort of the major non-United States economic power, those of my era who were recalled, it was the Japanese. And so in no small way, the United States Congress and the president is influenced by geopolitics. All of these things become important in terms of assessing this. And by the way, I have to say this because we really, really want people to be engaged in terms of political literacy and civic engagement. Elections matter. Mm-hmm. Elections have consequences. And I'm sure as the general counsel, and certainly Laurie Daniel Fabus will be aware, that which is interpreted by the Supreme Court is not platonic. It is not static. It depends who's on the Supreme Court, which makes the decision. For example, the whole question of, there was something about the impact on urban renewal. When in previous eras, and perhaps even to some extent today, if it smelled like a duck and looked like a duck, it was a duck. So you could infer that there was discrimination. It was called discriminatory effect or discriminatory impact, which is good. I mean, police brutality cases, oh, we didn't intend to do nothing. Mm-hmm. But if in fact it is narrowly interpreted and intent is the question, sometimes it's almost impossible to amass the information around intent. So I say that because we've heard over and over again the discussion on the part of some of our folks who have come to testify who are earnest in their effort to make sure that reparations gets through, that if you use race in any way or any aspect of race, that somehow it will be overruled. But the fact of the matter is, as you just saw in the testimony, if there's a sense on the basis of this court that anything smacks of race, diversity, equity, and inclusion was not specifically designed for Black people. They thought they're however interpreting it that way. Mm-hmm. So that becomes a huge challenge. I mean, the fact of the matter is reparations face a huge challenge in this period. Evanston, however, and just returning from Ghana, where Robin Ruth Simmons was there, her new name is Inaba. She is a citizen now of also Guinea-Bissau. So our sister has dual citizenship. And she had to raise to the floor in that august body that what is a threat to reparations here is a threat to reparations everywhere. So she raised that issue. However, it's going to be interesting, the Evanston decision, because it is very narrowly tailored, very narrowly tailored to, in fact, specific a specific era, specific harm, which is redlining, and having been involved in the certification of Evanston as a replicable model, and having encouraged our commissioners, and our chair did get a chance to go, and it's a great experience. You could actually read and see the actual documents where they said, we are going to do this, and they even talked about it. So it's going to be interesting. This is so narrowly terrible. So it'd be interesting to see how that one flow. Let me quickly just add a couple of other comments, because I think when our legal counsel says that the scope of New York's has been determined legislatively, it is, in terms of the definitions that have been laid out, it is the hybrid model. I think she said hybrid. We in National African American Reparations call it comprehensive reparations. We say by definition, of course, enslavement is, all of those papers are your due reparations, but we also say also the legacies. In the legislation, it says lingering effect. This is synonymous language, which means that it is not narrowly lineage-based per se. And it's interesting, and I watched this in California, which started off being narrowly lineage-based, kind of morphed, because if you're looking at the impacts, you're looking at whole neighborhoods that were taken down. So as you begin to look at it, the question becomes, if all of these harms have taken place, why would we limit it only to one category when there's so much that, I mean, they're just dropping $80 billion, trillion like water. I mean, so the resources, are there. So I think the whole question of comprehensive reparations bears examination. There are two final comments I'd like to make. One is that it still might be useful for representatives of those different jurisdictions. We know who they are. For them to come forward and share their experiences. One of the most interesting experiences I had in Evanston, because I go every year, we're sort of involved in it, was to hear how the San Francisco model worked. And they talked about it to the public, and then they said, don't do this, don't do that. So I think hearing their voices would be instructive to our commission per se, but also the audience that is also listening as well. Final thing I wanted to lay out is this concept. That is, within Evanston, one of the things that we did, and this is the other thing that might be a saving grace in some ways, and I know that we have begun to talk, at least on the expert committee, I forget what we're called, subject matter committee, about looking at corporations, the role of corporations, universities, and families who were involved in the slave trade and various forms of harm. The reason why that becomes important is because there is the opportunity actually to set up an independent mechanism. And we talk about that in terms of Evanston. If you read carefully the Evanston set up their own community controlled funding recipient mechanism. Why that becomes important is because from the corporations and so forth, those funds are not from the government. So those funds can go directly into a fund over which Black people have control. Doesn't mean you still can't escape, because they're coming at everything. I think the sister who, I forget her name now, has established a fund. But that is a route that I would also examine. I would encourage us to examine. So please forgive me for being a little bit winded, but when you get old, sometimes you talk a lot.
And there's a hand from Commissioner Daniel.
Commissioner Daniel Favors. Thank you, GC.
Yes, I just wanted to ask for clarification on that last point from Commissioner Daniels, because my understanding is that and General Counsel, I'm looking to you for guidance for this, the private nature of the funds that are sourcing that program are not sufficient such that it's not coming under attack. The Fearless Fund example is one such case where there were private donations. The issue wasn't the private or public source of the funding, as I recall. And again, I ask for a correction on this if I'm inaccurate. My understanding is that the issue in those cases was that
the recipient pool was limited to to people who were not white. And because of that, white Americans, European Americans made a decision to sue, but not based on the public or private nature of the funding, but because they could not get access to the applicant pool. Is that correct, General Counsel? Could you provide some guidance there?
That is my understanding, and I'd like to add another element to it. The independence of any potential body that is distributing is really, really, really important, because some funds have also come under attack because they were run by government. So you have the inclusion of race, which has caused some cacophony, and then it's managed by the government. That adds an element of complexity that we also need to be aware of. But yes, your recitation of the Fearless Fund case is my understanding, and I don't have anything to add to it. It was dead on.
Thank you.
Any other questions from our commissioners?
I'm all set. Great presentation.
Thank you, General Counsel Sneed Williams. We are grateful for your presentation and we look forward to future presentations. Before we hear from our Executive Director, I want to establish a quorum. So Madam Chair, would you please do roll call and confirm that we have a quorum? I'm sorry, Madam Secretary. I am the chair. Listen.
You are the chair.
It's Friday. I apologize. Let me do that
That's
again. Madam Secretary, can you please confirm that we have a quorum?
Certainly. Roll call. Dr. Chanel Hawkins.
Present.
Dr. Deborah Jenkins.
Present.
Linda Tarrant Reed. Present. Jennifer Jones Austin. Excused. Lurie Daniels Favors.
Present.
Dr. Ron Daniels.
Present.
Timothy R. Hogue.
Here.
Linda Brown Robinson. Excused. Dr. Derek Hamilton. Excused. Madam Chair, we have 5 commissioners present. Therefore, we have a quorum.
Thank you, Madam Secretary. With that said, we appreciate your support on this section of the agenda, and now we will move to our presentation from our Executive Director, Adem Jakwazi.
Thank you, Chair Hawkins. This presentation is expected to outline the Commission's activities from now to January 2029, when we exhaust our extension. This presentation is being, oh, what's going on? Oh. Okay. This presentation is being provided into 5 phases to understand the activities ahead of us. It includes our approach to stakeholder and community engagement, and also proposed schedule of meetings ahead of us for the next 2.5 years. Phase 1 of our activities, which ends this end of this year, we expect to complete the draft chapters for the history and the research and policy analysis. Once that is through, within the same time frame, we have the legal counsel working on the legal framework, the eligibility, and legislative audit. Part of it is what she presented today. Based on her assessment, this will be presented to the commission. Feedback will be provided and integrated into the draft document to determine the final definitions that the commission will be utilizing for its study. By the end of the period, we also anticipate that from the work of the policy analysis, we would have the general counsel look at the harms that have been caused, especially its connection with some policies or laws from the legal analysis to establish good legal standing for those harms. Currently, the economist team have developed a literature review of the models and the harms that have been utilized to value harms to determine the economic value of each of those. They've also started valuing some of the harms. They've delivered a draft assessment of the harms during the enslavement. These two documents have been reviewed by Commissioner Hamilton. We've had a meeting to discuss some areas of improvement and what the economist team can do to understand how some of the models can be improved. So it was a really good meeting with Dr. Hamilton, and we're looking forward to the updated document. By the end of this year, we know officially we've completed the public hearings, but we expect to engage stakeholders and the communities in a different light. We are still at the input phase, so we have developed a list of reparation advocacy groups that we intend to start connecting with very soon. Those are events that are going to take place while in a way to replace the public hearings that we are doing to make sure we are still in the public light. So we are going to roll out those programs sometime from October this year. Then we get to the phase 2 of the activities, which spans from January to June 2027. We anticipate that the commissioners would have reviewed or heard from our consultants working on the history and policy analysis and incorporate their feedback to update the reports. We also anticipate that within that time, the legal analysis of the policies would have been completed. Economics team would have also done the evaluations of the respective harms.
So Dim, I'm sorry for jumping in. I just have a question.
Okay.
You mentioned that we have completed what we believe all of our public hearings. And so I've been asked a question as I've been traveling around the state, as far as what, do we have a recommended cutoff date for public comments?
No.
We've put that out there, that just because we're not holding public hearings, that people still have the opportunity to provide testimony, public comment, recommendations. And so if we haven't discussed the cutoff date, I think we need to figure that out somewhere in this timeline as we're doing this work.
Okay, all right. Thank you. As of now, there's no cutoff date for receiving public testimony and all of that. What I know at this point is that the May 30th public hearing at Harlem was the last commission organized public hearings. There are going to be events which will mimic public hearings, but those would be with more of stakeholders for now, seeking additional input to what we are doing. We're going to have faith-based groups, reparation advocacy groups, talk to them because they've also been in this business for a while, and make sure we get their input into what we are working on. I don't know if it answers your question at this point.
Yeah, the only reason I was asking is because if people take the time to provide it, I just want the opportunity for it to be reviewed and possibly incorporated. That's all. I just didn't want people to be submitting stuff and we're already down the road on things. So that's all.
Okay. All right. Thank you. So within the second phase, we anticipate that the research findings will be completed. Once they are done, we begin to look at the policy options and recommendations. One approach we've considered and still recommend is having a think tank sessions. The vendors, commissioners, and other SMEs that we think could help us think through this going forward. For each policy option, we want to look at both the pros and the cons and make sure we are well aligned to avoid any potential unintended consequences, which happens a lot in policy development. So that will be an opportunity where we bring all minds together and figure out what the themes are, break them down, and look at the policy options going forward. Now, the current consultants could be part of that. So that is why I have them being part of the policy options and recommendation think tank group. Within that period, we have the communications team and the AV and videographer teams that will be supporting our activities through the appropriate communication strategies. It came up during the G6 presentation. They are very key to what we're doing. So once we flesh this out, we would need the communication team to provide the necessary support in terms of communicating this to the public and the relevant agencies. So we anticipate that by June 2027, a lot of the research work would have been completed, have a think tank session, understand the policy options that we're proposing, then expect that somewhere between July and December 2027, we would have the policy discussions drafted into the policy analysis to incorporated in the report. Within that period, we also expect that the legal counsel will start looking at the legal guidance in the development or the establishment of the bureau, which is part of the bit that instituted or probably established the commission, if I put it that way. So those are some of the things we are expecting that by end of next year, that opportunity would have been given to us for us to think through how we're going to establish the bureau and how it's going to perform. At that point, we anticipate that the economist team would have been done with what they are doing. Now, the strategy for communication is going to be in two parts. As we move ahead to complete the research findings, our engagement with the stakeholders or the communities will be more of collecting additional input. But once we get to the other side of it, where the research findings are done, the engagement is going to be different. At this point, we have some policies and we have some recommendations. Our engagement with the community will be focused on testing those recommendations and collecting feedback from the communities to ensure that the proposals that are, or the recommendations that are in the document aligns with expectations. Where we think that there's not alignment, we probably can come back with good reasons, refine the recommendations to align with the expectation of the communities. By January to June 2028, we would continue the public engagement on the findings that we said. So at this point, we put it on need basis because we would probably understand the frequency and the communities and the areas where some of these engagements will be taking place throughout the state. I know initially there was a program to do about 20 of those throughout the state. If it's possible, we'll probably flesh it out better and see how best to engage the communities and ensure maximum participation from the communities. Again, the communication team will be crucial in making sure that this phase of the public engagement is a success. By December 2028, we hope that we have the report ready, synthesizing all parts of it into a final report. I expect this to be done within this period. although we have a 6 months time frame, I see it maybe being done within the first half of this 6 months period that we're looking at. If there are any surprises, because these are estimations, if there are delays from there, it gives us enough slack to be able to move some of the activities forward. But as we have it now, by December 2028, we anticipate that our final report will be ready for submission in January. Now, at this point, we just have only one line here, but a lot of things are going to go into it. But this is just providing the broad line. We anticipate that editing of the document, graphics, printing, and all of those services will be attended to. But because this is just a highlight item, I don't want to get granular on some of those things. All right, so this already mentioned ahead of getting into this slide, talking about stakeholder engagement, pre-research findings and post-research findings. The focus of the engagement will be different between these two phases. One will be more of seeking additional input to what we are doing, whilst the latter will be more of sharing the findings from our research and the policy recommendations to make sure it's in alignment with expectation of the public. All right. Now, in terms of our operations, we have several meetings that we undertake. I am of the view that we can probably reduce the frequency of such meetings from the perspectives of time and cost, because any meeting that our vendors attend, again, they bill for it. So if some of these could probably be extended and use the time to probably for alternative activities, that would benefit the commission a lot. There are some cost assessments that have been made, and I humbly want to ask the commissioners and the commission itself if they could work with me on this. When we started, to make sure we get our feet to work, we had vendors coordination meeting. It started on weekly basis. Once we realized that we're getting things under control, we made it bi-weekly, and now we are meeting on weekly basis. Sorry, we're proposing to meet monthly. The next thing we are considering at this point is the liaison meetings. There are a couple of meetings that happen between commissioners and the consultants. For history policy analysts, they make bi-weekly. Communications team, they meet weekly. I'm of the view that if liaising with the team is to provide direction, then there's no point doing that on bi-weekly basis or weekly basis. So if commissioners will work with me on that, we are proposing that we do or we have such meetings bi-monthly. If anything happens in between, we will reach out to the commissioners to help it out. But again, bi-monthly meetings would be preferred. Then again, we have monthly business meetings. We have 2+ years to go, and if commissioners will work with me again, we will want to transition from the monthly meetings to bi-monthly meetings. A similar approach has been adopted for the executive committee meetings, which meets weekly. In my view, monthly meeting will be helpful for time and cost perspective. So these are the humble proposals that I want to put, I'm proposing to the commission for consideration. All right, so that brings me to the end of my presentation, and I'm ready to answer some of the questions, and I would really appreciate your feedback on this so we can incorporate them and work together as a commission. Thank you.
Thank you. We appreciate the presentation, Executive Director Jaquazi. And so, of course, we have questions, so we will yield. We heard New Rochelle, so we will yield to you all first.
Thank you, Chair. And thank you, Edom, for your presentation. There's a lot of work to be done and a lot of moving parts in order to create the final report. And as you outlined, we have the various vendors responsible for the various portions of the report. Keeping that in mind, I would be interested
Jim, we can
in
expand.
your approach to how you're going to combine all of those different areas into one comprehensive, cohesive report.
Yes, okay. So there are going to be individual reports for the various sections. Out of that, we intend to synthesize them. And out of that synthesis, we are going to also have an executive summary. Now, most people might not want to get into the technical analysis and all of that. So the executive summary would be the go-to document. But as it is scoped out, one of the consultants coming from PSA, which is the research historian, is expected to be the managing editor for putting these documents together, especially because managing the chronology of events is key. So I would be working with PSA to make sure that we get this report together to make sure that we drive it to the end.
Thank you. The other question I had was about the public hearings ending and the community, I'm going to call them workshops, commencing, in which we're going to be getting public, comments, public information. How do you see that working?
If my understanding of your question is right, we are looking at the second phase of engagement where we have our research findings and meeting with the public to let them understand what our recommendations are, right?
Okay.
Commissioner, is that your question at this point?
I was under the impression we had started community workshops, where we had a theme, and these were smaller workshops hosted by aligned groups. I was wondering if, in fact, we were going to refigure, that concept so that we could still be able to, attain the information from the community members across the state. Because I personally feel that we still need input, especially when it's guided input. The public hearings for me toward the end, the last, I'd say 6, 8, became incredibly informative because we had themes and people would talk about very specific subject. That to me was a great line to get the information that we need for the final report, especially utilizing the harms as, sort of like an outline and talking points. So I'm wondering, are we still going to be able to do something similar?
The engagement with the communities, as we said, the first part of it is going to engage other reparations advocacy groups, faith-based organizations. When we get to the second phase of it, we are going to organize those events with the association of the advocacy groups too, because like you said, we cannot do it in a in a silo. So we need the network to help with us, to work with us to reach the environments, the communities that we are talking about. So I am not too sure what you're proposing, because if it is something we've not thought of, I'm happy to include it in what we are thinking of.
So Dim, it's the small group settings that is put together by the same type of folks that you're talking about. So I think you guys are talking about the same thing in your phase one approach. And so I think the answer is yes, because I heard you mention it earlier in phase one. Phase two is a different approach, though, I believe. I
Okay.
can't see it totally because it's a little small, but I think you guys are saying the same thing.
Okay, so
All right.
again, we should talk about this.
Okay, no problem.
I'd like to chime in on that, on this part of it too, because I think that I'm hearing the engagement more from the community, which I obviously support. But I think there are two areas I'd like to stress. One is, and I think we mentioned this before, the opportunity actually to engage at least with the commission and perhaps with the commission and the vendors with some of the expert panels that were very, very, very instructive in many instances. The reality is, one of the critiques I would make of our hearing process, which is fine, because I think at one level, people just feeling that they said what they wanted to say is important. But in many instances, if we were doing gentrification, people coming forth were not necessarily talking about gentrification. So I'm saying that if we are going to have, and I'll give you a good example of an organization that I think that has been very good at this, and that's the ACLU. The ACLU has always come forward with specific policy proposals in specific areas. So I'm saying if we're going to do these workshops, I think they work best, not as a kind of, let's hear what you think and so forth. We've had a lot of that. And I think people, and I'm not even in favor of not doing some more of that at some point, but I think if we're going to get the quality that we need, then I think they need to be focused.
Right.
So if there's a neighborhood that we think was not sufficiently included, then we need to talk about the specificity of the range of issues in that neighborhood with people coming forward. For example, remember in Albany, I was very impressed with that one person who came forward with,
Yes.
I mean, that was very, I mean, with property, the documents.
Yes.
See, that's,
And that's what we
yeah,
need.
that's what we need. So whatever we do in that regard, we need to think about that. If we're going to get more input, it should be along those lines. The other thing is that I will specifically reference on the question of quantification methodology, which has been talked about, but the panel that we did on Staten Island, in which we had the economists, Hal Hamilton, well, I forget, and Malvo, and even though I recommended, I'm blanking on his name, from the Institute, they came up with these models. And I think it would be useful for us to have another session with them, because we had to cut it short. We didn't get as much time to explore it. And I think we even mentioned at that time that we would come back. And I know that the economist team got a little nervous. They thought we're not trying to get away from them, because they need to be a part of it.
Right.
So and in that regard, I'm also concerned a little bit about making sure that as we approach this, it is interdisciplinary in the sense that all the team are looking at this simultaneously in terms of creating the whole. So that would be one of my.
And I agree with you, because it has to be synergistic, and it has to be a narrative that is supported by the economists, by the policy analysts. So everybody needs to be working in concert. And that's why it is important to have, this is rudimentary, an outline that, really represents the story that we're trying to tell. So yes, it's based in history, but there's policy, there's laws. I mean, when I talk in terms of legal framework, I'm talking about the actual laws that impacted slavery and discrimination. I'm talking about the Black codes that started in 1626. I'm talking about, the Jim Crow laws that segregated us in all manner of life. And then the forthcoming civil rights movement, which the NAACP was the legal architect, which really fought against the discrimination, which is now being disassembled. So that's really where I see, the nuts and bolts of the legal framework. It's great to talk about other, reparations groups, that's fine. But the legal framework that we need to be focused on is the legal framework that impacts Black New Yorkers. I mean, because that is the case that we're making to New York State. And there are lots of policies that had been adopted and exist, but they have not been executed. And so, there's a way to do that kind of survey and to take stuff that's already been done, that's been ignored, and then reconstitute it.
Okay, Commissioner Tenry, let me say this, probably it might excite you. So at the last vendor coordination meeting, we have the economist team present the first part of the evaluations they've done. So the historians were there, policy analysts, legal was there. We discussed it amongst ourselves to understand where gaps are and what can be done to fill those gaps. Next meeting, General Counsel is presenting, coming up with the legal framework specifically for New York. We're going to discuss all of that. Once we go through this session, we would begin to schedule with the commissioners to have some of these discussions, because we want to run it through the technical side of it before we get to the commissioners. So expect some scheduling to discuss some of those products with you. You basically understand what the economics team is doing. If there are gaps, you want your feedback from the legal areas and all of that. So we've not done that yet because of where we are in the research, and you can attest to it from the history part of it and the policy analysis. So it's just a matter of time for us to schedule those activities with you, for you to have a better view of what's going on. But amongst with the vendors, we've already started it.
I have some comments.
Commissioner, I just want to say, Vice Chair, that we did have a hand raised for Commissioner Larry Daniel Favors.
But I don't have a way of raising my hand.
Okay,
Other than to just
I'm
say I would
sorry,
like to speak.
Vice Chair, we will yield
ahead.
to you because I don't see her any longer on the screen, so please.
Okay,
Happy to
thank you.
yield.
Okay, thank you. Okay, so I wanted to sort of go back to what Commissioner Hogues asked at the beginning about the testimonies of the public, right? We have gathered, and Dr. Daniels and I have bantered this back and forth between ourselves. We've gathered so much testimony, so much information. He just gave an example. I think we have to show fidelity to the people who have been coming to all of our public hearings for all of this time, to give them something. So that does go back to phase one. You said October. We need something before we start having true discussions about recommendations to get feedback from the public. I think we need to show them that we have really been paying attention to the things they've said, whether we agree with it or not. It is not about that, right? It is about them coming out, spending their time. The ACLU is a perfect example. We have not gone one place where we've heard them say the same thing over and over again, right? So that should be codified in a way that can do justice to the time they've spent. So that has got to be a part of this phase one planning. That's first, right? And then we'll get to the town hall type settings that also Dr. Daniels has been pushing for this entire time of the commission. I am concerned though, when you say individual reports by each vendor, because we want a narrative report to be our end thing, right? Yes. And if we have an economic report over here, a legal report over there, and so on and so forth, where do we come together to have that work synergized in and throughout the report. It just has to be something that is fluidly happening. And I'm glad that they were there. The other vendors were there when the economics team presented. But there should be some real work happening in those types of settings that said, okay, the research team has gotten this much information, the policy team has gotten this much information. Here is where the economic piece that you just presented will fit into this, because otherwise, when you gave that very tentative language about we hope, or at the end of December of 2028, we must have, right? That can't be tentative at all. It has to be, we will have the report ready so that the next month in January, we are giving it to the governor and the legislators. So we want to tighten up our own internal language so that there'll be no doubt that these deadlines are static, and they are happening. But December cannot be tentative at all. So I'm just asking you and the team, your team, the vendors, to do harder work, get some real dates about these phases, so that it's not just a time frame, which is perfect. We can work within that time frame, but give us some dates. And that just goes to the next point I wanted to make about these meetings. And with all due respect, I think it is for the executive committee to decide how often we meet. We don't always need operations or necessarily you, because you're having a cadence that with the ED on a regular basis. But as I said to you before, and I've said before in general, I am not willing, this is just one vote, I'm not willing until we have our budget to just relinquish everything. Because when I think about the question that Commissioner Terrence Reed just asked, that was really a question that came out of what your presentation was. And so those things have to be quickly addressed and responded to in a way that makes this commission feel like, okay, they got it, and I'm not there yet. I'm not comfortable saying that we as a commission is there yet. We are here to provide you with the support. And as I did promise you, and I did say to you, as it relates to policy, I am very pleased with what the policy team is doing, but I will make myself available to them as they see fit, right? We just had a meeting, and I did tell them that you and I had discussed this, and that I want them to get to the work. So if a meeting with me is going to slow down the work, hands off. However, the work has to continue. There has to be bigger updates than bi-monthly. I don't think we have the luxury of time or the confidence in the amount of work that has been done up until this point to say, we're only going to see you every other month. That doesn't work for me, So I think you might want to go back and look at those timeframes a little deeper, because we really have to get this right based on everything that's happening nationally and even internationally, right? We have to get this right. And I hope you understand what I'm saying when I share with you my comments.
And just to echo what Commissioner Jenkins just said, I work with the research historian, and I will meet with the research historian on an as-needed basis. Once a month is clearly not enough. And we've been working together for the past 18 months, maybe even 2 years. And we have been extremely productive in writing chapters and really doing the overview of the entire final report. So, and this is important to stick to a schedule. I mean, you have editorial schedules, you have production schedules. Right now, we're in the editorial phase of writing, researching, writing, editing. So it's very important that this is a very active phase. It's not just let somebody, leave them alone. They need guidance to make sure that they are adhering to what it is we need. The content has to be of this report.
I'd like to chime in on that as well, because you made reference to the meeting that was held, that you were excited about all the vendors coming together, what they were talking. See, I think it has to be established that the commissioners are not just here to listen, the commissioners not only are not here just to administrate, they are here to contribute.
Right.
So I think and I think I referenced this to you before, it's important for the commission to be in the middle of and hear some of those meetings. Because just as the economic team met with Professor Hamilton, which was correct, it's because Professor Hamilton is skilled in that area.
Right.
He's not just sitting here, and by the way, I'm not an economist, but I might have some ideas that as well. I'm not a lawyer, but I did manage an organization of lawyers. I mean, so people have ideas. And so those ideas need to be heard. So we're here also to not only to give guidance and to give input into the overall process. So I think as you're thinking about this, please think about it along those lines. You referenced again the whole notion of the think tank sessions, and I said I like the idea of those think tank sessions because that means that we all can be engaged not only in listening but hearing and giving recommendations and sharing our views and opinions about how the ultimate report and all will be shaped. So it's in that spirit. I hope that we're so delighted, by the way, to have the team together. And it must be said that we have been to some extent held back because we didn't have a full team. We now have a full team. And if we can just get our rhythm going in the appropriate way, and I'm confident that we will, and I'm delighted with how we're moving so far, I think we're going to really, really, really have an outstanding report.
All right. Commissioner Daniel. So I think there's a point that was missed in my delivery, although I mentioned that. Now, amongst the vendors, that is the first step to get the vendors to contribute to anything okay, the last meeting, we had the economist team present their valuation methodology and the models that they've used. We all contributed to it from different expertise. Once that is done, the next thing is get to the commissioners. And we are not just handing in a report, we are going to organize a session with you. So your contribution that you were talking about is definitely going to come on. But we want to make sure that there's a funnel in that a vendor produces a document, it goes through the team for us to discuss before we get to the commissioners level. So be rest assured that documents are going to come to you. We're going to do those presentations, get your feedback, and move on from there and get your feedback incorporated in the data. So we are good on that point. I don't have any problem with it. We will definitely get to you. There's been earlier contributions that have been made as to, I don't know if the impression is we don't know what we are doing and we are slacking, so we need the commissioners to sit on us to make sure we get to a certain point before they can set us free or something. So, no, hang on a second, please. You spoke, and I'm coming back to just tell you what I heard. If I'm wrong, please just let me know that I probably didn't understand what you're saying. But it appears that asking that some of these meetings be interspersed is the impression is that, oh, we are not where we are supposed to be. We don't have the confidence in you guys being there. So until we are sure you are there, then we'll leave you to move on. If I got it wrong, please let me know.
Well, who did you get this from? I mean, quantify and tell us who you got this, qualify rather, and tell us who you got this from, because we're all adults here, right? And I don't think that we can internalize this in a personal way. This is a high stakes commission, right?
Yes.
And we are all committed to it. And I include the staff, the contractors, the vendors in all. And if I use the word confident, I am certain I meant it. When I say that, I mean, because there are things, and I don't think they all have to be aired out here, that are not happening. And you really should want us to stay engaged until the whole team is operating at a level, not just churning out reports, not just churning out reports, right? But the little things that may to some seem like minutia, it's not. And so we are under a public eye. Everyone doesn't want this commission to succeed. And I think we always have to lead with that thought. No matter how small or insignificant a concern may seem to some, they can be those things that become a groundswell and cancel out all of the good work we've done. So please don't take it personal as an individual or any of the vendors. No one should. What I am saying is we still need engagement. I think you've heard that from all three of us in New York. You've heard that from us here in New Rochelle, right? And let me give you an example of something that I think you're going to need. When you get ready to do the think tanks, right? The only vendor who is a New York centered vendor is our general counsel and economics team, but to a different degree and a different way. So you can be confident that the general counsel can go into her resources throughout the state of New York and ensure that some of these think tanks happen. The other vendors are outside of New York, including yourself. You're by state, right? So how are you going to make those connections? We just heard from Dr. Daniels, who said he used to manage a group of lawyers. He's not a lawyer, but I used to manage a group of lawyers. Well, they are significantly important to this work as it relates to not only the legal framework, but the policies, right? You want to be able to go to Dr. Daniels and say, hey, can you activate that group for one of our think tanks? So you don't think of it as we're not confident in you. We just see that we're still needed, and we want and invite you to see the same thing. And so that's my response to that. If you can't qualify who said this, I'm accepting the word confidence as I just did, but I don't know if you want to exchange with us based on conjecture,
And let me just give you an example of just in this discourse. So we gave some examples of how we might move together and whatever, and you assured us that after the staff has met and so forth, we will have an opportunity to see the report. What I'm saying is we want to contribute to the report. That is pedagogically an entire different proposition. You see, because you have people here who have expertise in various areas. So what we're saying is in some of those sessions, we need to be there to hear and to provide guidance, to provide context and so forth. Because and there's also uneven development, frankly, in terms of, and we saw this frankly, in terms of hiring people and so forth. We did the best we can and so forth, but there are some people who are also themselves learning. Some of the vendors are learning as they're going.
Absolutely.
And so this is why we have this commission of people who bring various levels of experience and expertise. So none of this is being said in a way of we want to get it right. And by the way, too, I mean, I will say that I just asked, I mean, you presented your report, your outline and whatever. It would be good to have a copy of it. I mean, it would be good to have that in advance so we know what we're looking at. And that should be a part of the routine, part of what we're doing when we're having these kind of sessions and so forth. But on the major point, that is an example of what we're talking about in terms of an approach. Engage, and not to be oppressive, not to be overly micromanaging, but on the other hand, it is to make sure that there is the kind of input that needs to be gotten all the way around. That's the only concern.
Can I just acknowledge that Commissioner Daniel Favors, she's had her hand up.
Okay.
And she was supposed to speak after Dr. Jenkins. So if we could just let her speak, please.
Thank you, Madam Chair. I think if I could just offer a slightly different interpretation, as I've had, and I'm actually glad I was able to hear the discussion before I spoke. My takeaway from what our executive director suggested was that commissioner voices are intimately intertwined in the report, but that they're not going to be giving us rough drafts. That they would be giving commissioners, as opposed to giving commissioners the first iteration of a thing that comes from a vendor, what would be presented to the commissioners would be a cleaned up version of that has the capacity to be shaped and molded in light of what the executive director's team will know about what each of the vendors are doing. I actually took it more as managing up and managing down, because it is so difficult to get engagement on a regular basis from the commissioners to respond, that as opposed to having giving the commissioners a rough draft, giving the commissioners something that is substantive, that is cohesive, and that takes into account the other vendor positionings, so that what we're reviewing doesn't have to be reviewed 11 times before we get to the final point, but that what you would be receiving would be something that is contemplative of all of the different vendors that are producing and co-creating the report. So I just wanted to offer that as a slightly different interpretation that might, I think, bring together the fact that I don't know that we're saying anything different, but I just think that that slight nuance might have been missed.
All right. Thank you, Commissioner Daniel Favors. Thank you so much. I really appreciate it.
Okay. Any other questions here in Rochester?
We're good.
Okay.
I think it's a great conversation.
I absolutely think this is a great conversation. This will continue to be massaged, and we look forward to the continued work of the commission. With that, we are coming up on 5 o'clock. And I know that I just want to acknowledge if there's any new business for us to discuss. And I know we have a time restraint here. Commissioner Daniel Favors, you have your hand up.
Thank you, Madam Chair. I just want to publicly announce, because I know how the media gets, and I want to get ahead of conversation because we know how these things can go. I want to say that it has been an absolute pleasure to engage with each of you around the work of this commission. As you all know, when we first came on board, it was for 1 year. We've extended now to 2 years, and I am extremely glad that our legislature was able to extend the amount of time afforded to the commission so that this work can continue. But because of just lifing, I am just wanting to say thank you for allowing me the privilege to have served alongside you up until this point. I will be here on the commission. And I look forward to seeing you all to run the good race and continue to move forward. And I just want to say how grateful I am for this opportunity. And I will continue to be supporting the work of the commission from my non-commission life in the work at the Center for Law and Social Justice, and as somebody who believes in this work and looks forward to seeing it through, seeing how I can support you all continuing to move on in this work. So Madam Chair, I know this is something you and I have already discussed, but just wanted to publicly say how grateful I have been for the experience. And I look forward to seeing your continued success as a body.
Thank you. We are so grateful for your service. Commissioner Daniel Favor, can you just acknowledge, because there was just a little bit of breakup, when is your last day of service to the commission?
My last day of service will be June 30th, the end of the fiscal year. And so I'll be using my remaining days to wrap up any loose ends and make sure that there's an orderly transition.
Thank you. We want to publicly acknowledge the great work, your leadership. Let's give her a round of applause and thank you. We thank you. And we wish you continued success. And we are looking forward to partnering with you when it's time for us to share our report publicly. But thank you, Commissioner.
And we'll be listening to the podcast.
Yes.
Thank you. And I look forward to helping to amplify the work of the commission through the show, the podcast, and all other possibilities.
That's exactly how we hope to partner with you. So thank you. All right. With that, any other new business? With that, I am going to bring this meeting to a close and also announce that our next business meeting will be on July 10th. And so I want to thank all the commissioners for being here. I want to thank our General Counsel, India Sneed Wilson, for the presentation of the framework earlier, our Executive Director, Adem Jakwazi, and of course, all of the commissioners for their leadership. As a reminder, we are all volunteers in this work, and we spend it. You can look at the schedule and just see the current framework of how we are meeting weekly and bi-weekly doing this work. So this certainly is work that we are highly engaged in, highly committed to, and we look forward to next steps. So thank you all for attending this business meeting. We will see you all again on July 10th. Take care.
Thank you to the audience as well.
Thank you. We have a wonderful audience here in Nurse.